All right, let's hope we can move a little faster. But we are certainly welcoming you, Senator Vidak. This is file item 3, and before we start, it's my understanding the author will limit the scope of this bill to just Section 1 regarding mailing addresses, with a commitment to continue working on the substitute service provisions, and an understanding that this committee will call the bill back to hear any new substitute proposal that is developed. The amendments are not in the analysis, but you will indicate what those are in your opening statement. So this is another bill that we've been working on up to half an hour ago, or half an hour before we started. And if that is the correct understanding, if you'd indicate, and then go ahead and share with the members of the committee what the amendments will be.
I think your opening statement was fantastic, and I ask for your aye vote.
All right. Would you like to go ahead, though, and
Sure.
tell us what your
Absolutely.
amendments are?
Madam Chair and members, thank you. Thank you for the conversation we had. We narrowed the bill down to Section 1 with the understanding that we continue work on the issue of service. Section 1 will require a homeowners association to annually solicit their members the best mailing address to receive information from the association. I also want to thank Toby personally with the committee for working with us and the other stakeholders for the past 6 months. I have today with me Mike Belote with the trustees who are the sponsor of this bill, and I ask for your aye vote.
Thank you very much.
Madam Chair and members, Mike Belote on behalf of the United Trustees Association. In contrast to the first 2 bills you heard, which were big issues, this is a little issue. Here's the story. Our present law allows non-judicial foreclosure of condos for failing to pay homeowners association dues. In contrast to the treatment of mortgages, you have to personally serve documents relating to the foreclosure in the common interest development area. The law is silent, though, what happens if you can't find the person to serve them. We thought we had a good bill that had a good balance for the homeowners associations and the owners, but frankly, both of them objected to what we had. We really succeeded in that. The bill, as it has Section 1 in it, addresses the first problem. We need a good address, and this will, I think, help us get a good address for people who don't live in the condo where the delinquency exists. It doesn't address the second problem for a person who is just willfully evading a service of process. In litigation, as many of you know, what happens is you go in front of a judge and say, Judge, this is what we did to try to find the defendant, and we couldn't find her. The judge then issues an order to publish, and you proceed. But there's no case here, so there's no way to put it in front of a judge. We would like to move the bill because I think Section 1 is an improvement to the law, but we think we need to continue talking about what to do when service of process just can't be achieved. With that, we would ask for an aye vote, and I would echo Senator Vidak. Mr. Halverson has gone way beyond the call of duty in helping to bring the parties together on this, and we appreciate it.
Thank you very much. Any other witnesses in support?
Yes, Madam Chairman. Carter Glon. I'm an attorney with hundreds of association of clients throughout Northern California, and I've been asked to be here at the behest of Community Associations Institute. We think that this particular version of the bill is a good incremental improvement to the law with regard to this particular area, and goes to help create transparency in the entire process with regard to what's going forward here, and enhance communication between both owners and their association, as that has been a historic sticking point. And we think this does a good job of doing that. And currently, as it was printed, Community Associations Institute was opposed to the bill, but if it's amended as proposed here, we would move our position to support the bill.
Very good. Thank you very much. Any other witnesses in support? Witnesses in opposition? Any questions from the members? We have I'm sorry, I moved awfully quickly. Are you here in support or opposition? Opposition? Take a seat and share with us your name and your position, if you would. And remembering we're dealing with there's only one item left. It's in the first section. That is the section that remains today.
Concerning addresses,
Yes.
I'm Marjorie Murray, Center for California Homeowner Association Law. We're a statewide nonprofit that advocates for homeowners who live in associations. This is a long-standing issue, the personal service issue. Jackie Spear tried to get it into statute 20 years ago. It was finally put into statute in 2004 after an association foreclosed on an owner for owing $120. So, as Jackie Spear said in her letter of opposition to this bill, that this would be a step backwards, obviously, to weaken or even to delete altogether the personal service requirement. Now, one of the sentences in the analysis is that there is no case law on the issue of service. And I think the analysis was talking about substitute service, but I do want to point out that the appellate courts have addressed the issue of service in the Diamond case, where the owner did not get either the notice of default personally served or the board's vote to foreclose. So I'm actually not clear at this point where the bill stands. We were not part of the conversation to shrink the bill down to Section 1. We would be extremely concerned if this bill then became an opportunity to add things to it that we have objected to in meetings with the sponsors of the bill. And one of the things I really want to emphasize is that when we first began meeting with the sponsors in October, the first question we asked was, where is the evidence? Where are the reports? I mean, this is one of the biggest association debt collectors in the state, if not the country. We asked for reports and data and evidence that homeowners cannot be personally served. The sponsors of the bill are not able to provide it. So,
Okay. At this point in time, I can assure you that by removing Section 7, we're not talking about the actual service. What we're trying to do with Section 1 is simply improve information that is available to the Homeowners Association, requiring an annual reporting of an address. We are not talking about service, substituted service, or anything. We will continue to have those conversations so that we can do what we believe is the fairest for those people who are considered delinquent in the payment of their homeowners association dues. And that, we've all read, I think we read former Senator, now Congresswoman Spear's objection, her concerns. They've been articulated to the author and to the supporters of the bill, and we're going to continue to try to work on that issue. But that issue is not what is now before us. We've removed that section from the bill. Your concerns are duly noted. Hopefully the conversations will continue. So I hope that, and your 2 minutes is up.
I just wanted to say, Madam Chair, that Section 1 actually came from us.
I know it did, and thank you very much for that section. We appreciate it. So we're on the same page here. I think since it came from you and we're adopting it, I think you're ahead. So next witness.
So with those amendments, maybe
Tell me your name and affiliation, please.
Kent Chan from National Housing Law Project. With those amendments, maybe I'm not neither in support nor opposed, but we just would like to express our reservation on the changes to the service requirement because this foreclosure can still be accomplished with judicial foreclosure. So these changes are unnecessary.
That's true. All right. Thank you very much. Any other witnesses in opposition? Any questions from the members?
Norma Garcia.
Oh, I'm sorry.
Senior Attorney, Consumers Union. We share the concerns of the other witnesses in opposition and hope to see this bill turn into something that is acceptable. If it eliminates personal service, we are definitely against it.
Your concerns are duly noted. Thank you. Any other witnesses in opposition?
Sorry, thank you. I'm with the Carol Bailey with the California Alliance for Retired Americans. We too have not seen the amendment, so we can't be clear. But the impact on seniors has been monumental. And we do have cases, and we do know people where things are supposedly tacked to a door, or, sir, I know, I have 2 minutes.
We are not going to address that issue now because those concerns still need further discussion. But the notice issue, the first section, which you have seen if you've seen the bill, is the only thing we're voting on today.
Okay.
Okay, great. Thank you. And I understand your concerns. They're shared by, I think, a lot of people, and that's why we're going to continue that conversation.
Jerry Bailey, and I'm also a member of California Alliance for Retired Americans. I'm in opposition to the bill.
Thank you, sir.
Madam Chair, Kevin Stein, California Reinvestment Coalition. Just want to echo the concerns about weakening protections for consumers going forward. Thank you.
Duly noted. Thank you. Any other witnesses in opposition? Any discussion? Seeing, hearing none, is there a motion? Moved by Senator Morlock. Please call the roll. As amended, yes. The motion is do pass as amended to the Senate floor. Would you like to close, Senator Vidak?
I ask for your aye vote. Thank you.
I knew that was it. Okay, very good. Please call the roll.
The motion is do pass as amended to the Senate floor. Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Anderson, aye. Hertzberg? Leno? Leno, aye. Monning? Monning, aye. Wachowski?
Aye.
Wachowski, aye.
6-0, that bill is out, and I look forward to continuing to work with you to get a good bill. Thank you. All right, file item 4, Senator Vidak. Another easy one.
Another easy one.
Okay. All right. Senator Vidak, if you'd like to proceed.
Thank you. Madam Chair and members, nearly 1,300 properties have been identified by the High-Speed Rail Authority as necessary to complete the 120-mile route from Madera to Bakersfield. While these properties have been identified to complete the current alignment, there is always a possibility that the route may change or that the project is never completed, leaving the state holding on to properties it no longer needs. Current law allows the authority to sell off land that it deems not necessary, but previous landowners are not notified that the land is going to be sold. SB 940 requires the High-Speed Rail Authority to notify the previous landowner if the land is going to be sold and requires the authority to wait 30 days after sending the notification before selling the property.
Any witnesses in support? Witnesses in opposition? There's a motion by Senator Leno. Thank you, Senator Vidak. I think this is reasonable, and I will support as well. All right, let's call the roll. The motion is a do pass to Senate appropriations.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Aye. Anderson, aye. Hertzberg? Leno? Aye. Leno, aye. Monning? Aye. Monning, aye. Wachowski?
Aye.
Wachowski, aye.
6-0, that bill is out. Thank you very much, Senator.
Very much.
Vidak, your loquaciousness is always appreciated.
Truth and science.
All right, we have, I guess, the only other non-member is file item 10. Senator Allen, you're up. Oh, okay. And Senator Hancock, if her office is hearing this, she is up next. Senator Hancock, we'd love to see you. Senator Allen. I believe there are some amendments, and if you'd like to introduce the bill as amended, so we will focus on what those amendments are.
Absolutely, and from a judicial perspective, from a judiciary perspective, it's a significant change, and I'll explain it in a second. So, SB 1161 looks at looks to allow our California Attorney General or a county district attorney to bring legal action against a business that has committed unlawful, unfair, or fraudulent business acts or practices and unfair, deceptive, untrue, or misleading advertising as it relates to climate change. Now, in print, the bill extends the statute of limitations in this area from 4 to 30 years. But after discussions with the with the committee, along with the author's amendments mentioned in the analysis, I'd like to follow the recommendation listed in item 4 of the analysis and amend the bill to allow for a one-time revival period that, for these claims that might otherwise have been time barred. So now, instead of the bill allowing for a 30-year statute of limitations, the bill would now allow for a one-time 4-year revival of claims that would have expired otherwise as of January 1st, 2017. So starting January 1st, 2017, our Attorney General or District Attorney could revive claims that would have otherwise expired under the statute of limitations for a 4-year period. They'd have 4 years to do it, and then that would be over, and they would not be able to raise those claims again. I'm happy to talk about why that's a good thing for a lot of different reasons, but I'm happy to have accepted the amendment and appreciate the work of the staff in helping us to get there. So now, one thing that's important to mention is that as proposed to be amended, the bill still does not create any new liabilities in state law. It does not presume that any fossil fuel companies or trade associations have broken the law. That would be something ultimately for those public attorneys that we have entrusted to enforce the law and our district attorneys and our attorney general, and then potentially the courts, to decide. They would decide on the merits of whether misinformation campaigns related to climate change violated California's unfair competition law. Now, what brings us to this moment? I just want to remind folks of the fact that internal fossil fuel industry documents that have been uncovered expose a deception of really, if true, unprecedented scope that warrants giving law enforcement the opportunity to ensure that justice is served for the full weight of any violations that may have been committed, and to give them the right to pursue this as part of a civil action. These documents show that many of the world's largest fossil fuel companies have worked to deceive the public about the realities and risks of climate change for decades. According to documents that have been uncovered, the industry was well aware that burning their product contributed to climate change and that climate change would have, quote, globally catastrophic effects. Further, internal documents dating back to the early 1990s appear to show a series of carefully planned campaigns of deception organized by companies and trade groups representing the industry. And according to one of the uncovered memos that was developed by the American Petroleum Institute, their campaign would achieve victory when, quote, average citizens and the media were convinced of uncertainties in climate science. Since 1988, when it appeared that fossil fuel companies knew the risks and likely consequences to the climate of processing and burning their products, carbon emissions have doubled. Now, they're already changing our climate, putting our communities' health and economy at risk due to longer and more damaging wildfire seasons, more frequent and intense heat waves, rising sea level, which will threaten our coast and our coastal communities, and of course, drought. And if the allegations, which are currently being investigated by several attorneys general, prove true, then their actions would represent, in scale and duration, a deception rivaling, in fact, surpassing that of the tobacco industry. So that's what brings us to this occasion. And of course, the public makes it clear on issues such as tobacco and asbestos and lead that companies can and should be held liable when they fail to acknowledge and address the known negative impacts of their products on human health and well-being. And the same is absolutely true for climate change. I argue strongly that the state has a compelling interest in ensuring the question of accountability is addressed on its merits. This bill allows that to happen. The opposition letter speaks to concern that statutes of limitations should be taken seriously and serve a purpose. I couldn't agree more, and I believe that we should tread very deliberately and carefully when we make changes, as we have with this bill. And I think part of the amendment speaks to that. But this is not a typical unfair competition case. This is a different kind of case. The scale and nature of the deception in this case, the resulting historic and global impacts are truly unprecedented and of incredibly grand scale, and I believe they merit this level of action. I have with me today Edward Parson from the law school at UCLA and works on international environmental law, and also we have Jason Barbos from UCS, the Union of Concerned Scientists, who is here to help with that, to answer any questions.
Thank you very much. Good afternoon, folks. 2 minutes each, and name and if you would identify yourselves.
Thank you. I'm Ted Parson from the Emmett Institute on Climate Change and the Environment and the Law School at UCLA. I brought along printed copies of my testimony for the committee.
It would be great if you give those to the sergeant. He will pass them out.
So I'm going to highlight 3 points very briefly that relate to the nature and significance of the false and deceptive claims that are the focus of this bill. First, core elements of the scientific knowledge that establish the reality and seriousness of human-caused climate change are not in doubt, they are not new science, and they have not been in doubt for many years. Key elements of the modern understanding of how human emissions of greenhouse gases can change the climate were known not 20 years ago, not 50 years ago, but before the turn of the 20th century. The major uncertainties that might have had the consequence of making human emissions of greenhouse gases no big deal were put to rest roughly by the early 1960s, to such a degree that the first authoritative scientific report to a United States president on the issue was delivered in 1965 to President Lyndon Johnson. All the major pieces of the current understanding were well in place by the late 1980s, sufficient to motivate a serious program of pursuit of national and international action to reduce emissions. Second, the systematic, sophisticated, and well-funded campaign to deny and obscure scientific knowledge of climate change that expanded in the early 90s was sometimes characterized as scientific opposition, but it had nothing in common with scientific debate and activity in its process, its methods, its motivations, or its openness to contrary argument and evidence. It was really nothing but a large-scale public relations campaign aimed mainly to confuse the public and obscure scientific knowledge to strengthen and sustain the competitive position of fossil fuel positions against other energy sources that they would face competitive pressure with if the public took seriously the risks. Third and finally, the consequences of the 25-year delay in undertaking serious activity to reduce emissions, which may still be with us, notwithstanding glowing success stories like California and the recent moderately good news out of Paris, has cost a huge amount in terms of lost opportunities to manage these risks. In my testimony, I show a chart that identifies how world emissions of greenhouse gases consistently for the past 25 years, yes, thank you, that's it, have tracked the very top end of the scenarios of emission projections that have been produced by various authoritative bodies. 3 times such scenarios have been produced. Each time they attempt to capture the range of possibility from what happens if we do nothing and things grow into business as usual to what happens if we take serious but measured, feasible efforts to control emissions. We've consistently tracked the top. I attempt in my written testimony, I won't go into the calculation, to calculate what I call the lost opportunity of missed opportunities to cut emissions. It is very serious. It has done grave harm in the period that these misleading claims have been outstanding. Thank you, Madam Chairman and members of the committee.
Thank you very much. Appreciate your testimony. If you would briefly.
Thank you, Madam Chair. I'm Carol Muffett, President of the Center for International Environmental Law, and I speak today in support of Senate Bill 1161. As California and the world suffer the growing impacts of climate change, mounting evidence is demonstrating that fossil fuel companies understood climate science and had notice of climate risks far earlier than was widely known. This evidence throws corporate funding of climate misinformation into new and legally significant light. SB 1161 is a reasonable and necessary measure to ensure that state attorneys can fully investigate and fairly litigate acts of unfair competition relating to climate science. It does this by reviving, for 4 years, causes of action that may otherwise have been barred by the statute of limitations. Much information concerning what companies knew about climate science has come to light only in the past year. Thus, many claims were not only undiscovered, but likely undiscoverable until recently. Ongoing revelations may lead to the accrual of still additional claims. SB 1161 ensures state attorneys have time to investigate and fully assess which, if any, claims are warranted and against whom, without risk of being barred by a statute of limitations whose start and end dates are presently very uncertain. The result will be better defined and better supported claims. SB 1161 will also reduce unnecessary and costly procedural litigation that could delay cases reaching the merits or even discovery for years. More fundamentally, SB 1161 reflects California's compelling policy interest in bringing the truth to light. The state's interest in access to justice warrants the exercise of a revival power that is well within its right. If a defendant misled the public with respect to climate science for years or decades, barring claims precisely because the truth was successfully concealed would reward that conduct and effect a profound travesty of justice. SB 1161 does not prejudge the outcome of any case. It simply ensures that the issue can be tried on its merits. Thank you.
Thank you very much. Appreciate both of you being here. Those in support, if you just step up with your name, affiliation.
Jason Barbos with the Union of Concerned Scientists. We're the sponsor of the bill. Appreciate the committee's help in refining it and ask for your support. Thank you.
Good afternoon. Diana Vasquez, Sierra Club, California, in strong support of the bill.
Thank you.
Hello, I'm Victoria Rome with the Natural Resources Defense Council in support. Thank you.
Kyle Jones for California League of Conservation Voters in support. Thank you.
Thank you, Kyle.
Elena Galloway with Environment California, and we'd like to thank Senator Allen for writing the bill, and we are in support of the bill.
Thank you. Other witnesses in support?
Sabina Tacker with the Consumer Attorneys of California in support.
Thank you. Any other witnesses in support? Opposition? Opposition, if you'd step forward. Again, I'd like you to address the amendments which call for the 4-year revival period. We're not talking about a 30-year statute of limitations.
Thank you, Madam Chair and members. Hal Dassing with the Civil Justice Association. So I apologize. I am trying to listen closely, but are we talking about going back 4 years and not 30? Is that what you just clarified?
Correct. It's a 4-year revival period for these claims. And I believe they're listed in, there's a mock-up of this that reflects those changes. And that's, we're not talking about a 30-year statute. We've narrowed it down to a 4-year revival period for claims. And if you haven't had a chance to see, do you have it? Do you have it?
I do not. I haven't seen them yet, but I look forward to looking at them.
Yes.
And certainly want to engage with the author once we get a chance to look at them and with our organization and see if that changes our position. I will not address the 30-year statute of limitations, but will reiterate those parts of our opposition that are affected by the bill, even as amended. First, we continue to believe, both because of the author's presentation and support for the bill and because of current law, that the bill is unnecessary. It has been mentioned several times that they believe that the conduct has been continuous, and if that's the case, then both the delayed discovery rule and the theory of ongoing conduct would allow prosecution of these cases now, despite, they can go back even despite the 4-year statute of limitations. We also note that the author's statement in support of the bill says that the Attorney General has opened an investigation. We believe the current law adequately provides for the prosecution of these cases, and in addition, there are a number of environmental laws that could be applied. And the remainder of our opposition focuses on the 30 years, so
I figured as
ask
much.
for a no vote.
Okay, thank you. Nice color.
I will, Amy Maga on behalf of the California Chamber of Commerce, currently have an opposed position. I will reiterate, we share the concerns of the Civil Justice Association of California. We have not seen the new bill as proposed. Therefore, I will align my comments with his, and we look forward to seeing those amendments, working with the author's office. Thank you.
Very good. Thank you. Other witnesses in opposition?
Yes, Madam Chairwoman, Michael Shaw, California Manufacturers Technology Association. And just to seek clarification, the 4-year revival period allows claims to go back an indefinite period of time?
Let's see. No, it refers to a revival. Cause of action may be commenced within 4 years of January 1, 2017, but nothing in this subdivision shall be construed to alter the applicable statute of limitations period of an action that is not barred as of January 1, 2017.
Okay. So, and not having seen the amendments, we continue to share the concerns, and we believe that extending or in any manner the statute of limitations for claims regarding actions that took place, many years ago in this case, would be inappropriate, would set a dangerous precedent, and really go against, I think, public policy in California that we would allow for actions that far back, in this case, to go forward under a retroactive application. Thank you.
Thank you. Other witnesses in opposition? Good afternoon.
Good afternoon, Madam Chair. P. Anthony Thomas, representing the California Independent Petroleum Association. I will associate my comments and my statements with the manufacturers as well. We're in opposition. Thank you very much, Madam Chair.
Thank you.
Good afternoon, Chair, members. Ken DeWorth, the National Federation of Independent Business, and we also are opposed for the same reasons.
Madam Chair, Member Shane Levine, on behalf of the American Insurance Association, will certainly look at and consider the amendments, but at this point we are opposed. Thank you.
Madam Chair, Russell Nowak on behalf of the American Chemistry Council and also SIOMA in opposition.
Thank you. All right. Any other witnesses in opposition? Any questions from the members? Senator Leno.
Thank you, Madam Chair. Senator Allen, I can't help but be reminded of a really powerful documentary, which I suspect you may have seen, called Merchants of Doubt, which has any number of interviews with the very PR geniuses who make the statement on camera that if an industry such as tobacco could actually deceive the American public into believing that tobacco was not a dangerous product, imagine using that model what else you could do to deceive the American public. And they just use their imaginations. And I was fascinated by the title of the film, Merchants of Doubt, because so often when we put forward consumer bills, our colleagues, when we come to committee, rightfully expect us to be able to determine the point we're making, that there is risk to consumers 100%. All the opposition has to do is come in and sprinkle some doubt. And then colleagues say, well, I'm not a scientist, I can't make these decisions, and the bills die. But these folks were PR and continue to be PR geniuses, and they've taken that tobacco model, the 80,000 untested chemicals in our environment, and the whole debate of climate change, as if there is a real debate, because there is just a little doubt, even though 99.5% of scientists have documented the seriousness. And with the rate at which it is now happening on all parts of the globe, this is such a very, very serious issue. So I think the committee member amendments appropriately temper the bill. And as you are amending it, I'm pleased to join you as a co-author. I move the bill as amended.
Thank you. Any other comments from the members? I would just align myself with the remarks of Senator Leno. The ability of some of these industries to deceive the American people and the consequences associated with that are stunning and should not, in my opinion, be allowed to go unchallenged. And what we've done with this bill is recognizing the disfavor of lengthy statutes of limitations for a variety of reasons by providing this 4-year revival period, sort of modeled, I think, on what Senator Burton did back in 2002 with SB 1779, one-time effort so that we can sort of pinpoint and focus on behavior that arguably could and perhaps should be brought to the attention of the public, and the consequences of it be presented in a court of law with potential liability being considered. I think this is a bill that does balance that, and I appreciate your willingness to take those amendments. But I apologize to the opposition that we didn't get these to you beforehand, but it's very clear that there still is a desire and a public interest to be served by having this revival period to be able to address these issues. And I appreciate your willingness to work with us in this, and I too would like to be added as a co-author of this bill. So unless there are any other questions, is there a motion by Senator Leno to pass as amended to the Senate floor? Madam Secretary, please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, no. Anderson? Anderson, no. Hertzberg? Leno? Leno, aye. Monning? Monning, aye. Wachowski.
Aye.
Wachowski, aye.
All right, 4-2, that bill is out. Thank you, Senator Allen. Next up is item 5, Senator Hancock.